arrested from the prison and brought here forcefully. First time I'm being arrested in prison. So we didn't come prepared. If what I heard and I have recounted is the case, then quite clearly the intention of this process is not a fair trial. Very clearly.
Criminal case number 335 of 2025, Uganda vs. Uganda Kizza Besigye and Obeid Lutale, R/12743, Captain Nicola Delishoya.
May it please this honorable court, I'm Thomas Jatiko, Assistant Director of Public Prosecution. I'm appearing together this afternoon with Richard Derevunguka, Chief State Attorney. My Lord, the three accused persons are present in court. However, my Lord, the counsel representing the accused persons are all jointly and severally not present in court right now. My Lord, this matter was adjourned to today, the 13th of July. For hearing of the prosecution case as per the ruling that we received. And my Lord, the prosecution is ready to proceed.
Say you are ready to proceed.
Yes, the witnesses in the court premises.
The witnesses are...
They are around, not inside the court here, my Lord.
Because I came here by duress.
Then first remove the handcuffs, then the addresses. signed a report on the issue of legal representation, why they are not here.
Yes.
Legal representation.
Mr. when we were last here on the 3rd of July this year, we did address court on the challenges of our representation and that we had filed an application number 248 seeking remedies relating to our representation. That was not responded to. And actually on the very following day, on Saturday, the 4th, Mr. Museveni addressed the country, touching on the matters before this court. In his long address, the long and short of it that I picked related to our case, is that there is indigenous community justice.
Let me first get the reason why the lawyers are not here.
I am explaining the background to that.
No, the matter was coming for hearing today.
Yes.
So tell me why the challenge you have for legal representation, why they are not here. I want to capture that.
Yes, so I'm talking about the reason of fair hearing, which requires us to be represented by lawyers of our choice. But the reason I am referring to what? Yes.
The reason is a fair hearing
Yes.
by the lawyers of your choice.
Through a representation by lawyers of our choice. And the reason I was referring to what was said on Saturday is that belief of ours that we have a right to a fair hearing with the representation of lawyers of our choice is clearly in question. Because from what
Is there anybody who has refused you that right of the choice of the lawyers?
Yes, there is.
Moving now.
And that is the subject of the application we made to this court on application 248. surprised that indeed, in spite of what the representations we made here on the 3rd, which included 3 main points.
This application is about what?
3 main points. The application is mainly about legal representation. But beyond that, I addressed you on the question of us receiving the evidence that was given to our lawyers. It was read, a letter was read in this court on the 3rd. Permitting access to us by our lawyers with the facilities to hear the disclosures. That letter was written on the 2nd of July. It was read in this court on the 3rd.
I would say still there is a challenge to access the facilities.
Of course. So, up to today, we have not, because that is related to our legal representation. We want to hear the evidence together with our lawyers. We haven't had the opportunity to do so up to today. And I made this very clear on the 3rd.
So, kindly be specific. The challenge is legal representation. Why they are not here?
So you want to listen to the application?
So it is in that application?
It is in the application.
The 248.
Absolutely. That application was even touching on the earlier application, 227, where we never served the respondents.
So you are saying
that application you gave a ruling even before we served the correspondents and the respondents in that application. Application 248 was actually also seeking for substituted service so that we could serve the respondents in 227, in the application number 227, which now has already been ruled.
So you are saying that now there is that one pending, 248.
So there is application 248 pending. There is access to the disclosures, which we have never had. And we had also requested, the third issue we had requested, for a record of proceedings.
For which one? Because the records are mainly for...
A record of the proceedings so far
In the main?
in the main case. In the main and in the application that we had made. And regarding that, it was even a part of what was presented by Counsel Elias Lukwago among the 7 items that needed to be dealt with in the preliminary hearing.
So let me know those challenges you have in legal representation now. What is your issue? What are you requesting?
So, our request, which I made even on the 3rd, it was not responded to, is that our application 248 be heard, so that we can resolve the question of representation. Once the question of representation is resolved, we shall have access to the disclosure. Hopefully then, in that period, we shall also have had the record of proceedings, and we shall be ready for trial. Nobody wants to stay in prison. And this is why, Mr. Judge, the address of Mr. Museveni on Saturday the 4th is critical also in this case, because he addressed the nation, the whole country, on our trial. And on something totally unknown to me called the indigenous justice system.
We need to know, let me first conclude the challenges now for commencement of the trial today. I have seen...
So the 3 challenges...
There is a pending application.
Yes.
The record of the proceedings.
And the disclosures which follow on the representation. And these are not new demands. They have been before this court in writing and orally.
So let me get this. The disclosures which were made to your lawyers, are you saying you want also to give them to you?
They are for us. We haven't received them because we need facilities to do so. And that's what I was complaining about last time, because we make presentations to court, they are totally ignored, and matters continue as if we did not say anything. And that's why today we had said no. And we wrote a letter. Unfortunately, that letter I think also was detained by the prisons. We wrote a letter on Friday last week, expressing further our dilemma. Having received the ruling, I think that day, saying that the hearing was to begin today, we wrote a letter on Friday. I doubt that it is yet before court. Prisons have it. So we have challenges in prison, we have challenges in court.
Can I hear from this one?
Well, I wanted to address you on the environment that has been caused now by the address of Mr. Museveni on Saturday on this case. Because it is before you.
Let me first listen the challenges for hearing today and why the lawyers are not here.
And then I will come back. No
I
problem.
must resolve that.
No.
My Lord, for record, Captain Dennis Oyamora, April. I want to be very brief. Most of the things have been said by everyone. But I want to talk specifically concerning myself and possibly why the lawyers are not here. The last time we were here on that,
The reason why the lawyers are not here is
when we were here on that, you promised to give a ruling of that day by 8. As I talked of now, I've never received any.
I've never received
The ruling of that day. And even coming to court, I was just told today by 9. You promised to give a ruling on that day. I did. Not at all. And for today's hearing, they did not tell me that I was coming for hearing. They just informed me that I'm coming to court today at 9. I had no idea that court would be there today. And therefore I have never contacted my lawyers. And I'm not sure whether they are also aware that court was supposed to be there today. So, to tell court why they are not here, I'm really not in the position. Because personally, I never knew there was court session today. It's my prayer that next time service of such should really be done to all, so that we can prepare. But in addition, there is still also need for me to have access to the facilities, and so that I can get to understand what is in the disclosure. Thereafter, I will be ready for hearing. Thank you.
Please, can I get to make
But you are given a dozen.
you still want to say,
Yes.
I don't, you go ahead. So
Yes.
the-
Mr. Judge, the reason
That's the reason.
again, all these touches on the fair hearing, you know,
I'm giving you another chance to address court on the legal representation, which is affecting today's hearing. So that I'm able to respond.
I have addressed court regarding the legal representation. I want to address court regarding the statement of Mr. Museveni, which touches on the fair hearing of this case.
That one, today we are not handling that. Today it is here. So let me get the challenges you have for here.
Precisely, this is a challenge for our hearing. Because statements that were made touch on this hearing.
That one I have captured that.
Yes, so let me tell you what they are.
No, you can't go to that address. I need to know the challenge you have told the court.
That is a challenge. The address is a challenge. Because it's an address to the whole country, it affects the nature of this case, it influences the assessors, it influences everybody in this case, including yourself.
I am saying that you can address me, if you have already addressed me on the challenges of legal representation.
Yes, and this is a challenge on this fair hearing before you. So I can go ahead and address you on it.
You have addressed both of the challenges of legal representation today.
Yes, I'm not addressing you further on the challenge of legal representation. I'm
Today we are
addressing
here
you.
for hearing.
I'm addressing you on what Mr. Museveni said on Saturday the 4th, which has
The
proved.
problem before court to resolve is legal representation, the challenge you have.
So when do I raise this?
You said there is an application. You want me to listen to the application in court? You said there is a pending application.
Yes.
You want to add it to now?
The pending application is on the representation.
And that's what we are handling now. So what you are saying, we cannot go to the merit of that case. What you are saying. But today let us handle why you cannot proceed.
I don't know whether you have received the letter we wrote on Friday to this court, because it also contained some of these matters.
You also wrote a letter.
Yes, which is with the prisons authorities. And they are here, maybe they can confirm whether they have brought it or to have it.
About the same.
Yes, about these issues. I want it to be on record.
So that road, so that
So the letter has been received.
I will go with it. I will go with it. Treason. Can I know the letter? Was it what did you find?
Yes, my lord. My lord, I'm assistant superintendent for prisons. Superintendent of prison. For the letter in question, I'm assistant superintendent of prisons, Hero Emmanuel. Hero Emmanuel.
Yes, about the letter.
My lord, all article is written. They go through a verification process before they are forwarded. All articles written by the accused, they undergo a verification
Is
process.
this for what they do is still undergoing? That's what they do.
I need to confirm the status of the said data.
You are not sure what's going on.
Yes, my lord.
Okay, let us take a reply and let us use.
I forgot to mention, I forgot to mention that we have also filed a notice wishes to appeal your ruling. Appeal the ruling in our application 07. And we then need the record of proceedings to proceed with that appeal.
So you are not so appeal which ruling?
In the ruling of application number 227. That is the human rights enforcement application.
It's noted. So state.
For record, my lord, Richard B. Vumbuka, Chief Secretary. For prosecution. My lord, in response to the issue of representation, the accused persons, maybe to start with A1 and A2, maybe that's why it is more contentious. Are represented by more than 35 lawyers. A1 and A2 are represented by more than 35 advocates. And they have been on record since this matter, my lord, moved from the Chief Magistrate's Court, Nakawa, to this honorable court. My lord, would appreciate the right of the accused persons to legal representation and more so by advocates of their choice. As envisaged under Article 28 of the Constitution, and Section 56 of the Trial on Indictments Act. Because it constitutes part of the fair hearing. My lord, since the last sitting, A1 and A2 have been unrepresented. Unrepresented. And in this submission, that is our senior citizen and great statesman, Dr. Uganda Kizza Besigye, one, he submitted that the lawyers were not in court because Senior Counsel Martha Karua, last time, even last time, yes, my lord.
But reply.
Yes, I'm bringing my thing properly, my lord.
Yes, but reply.
I'm rebutting it, my lord. Because without that, I can't make my point. He argued that they were not in court simply because Martha Karua and
Mr. Lee.
yes, my lord.
I didn't hear you talk about Massa and others. We first help courts to address the concerns, their concerns today, why this...
My lord, it's going to help you in this matter very well.
No,
but I'm not going to do it much.
What his,
okay, my lord. My lord, we have never received any notice we have never received any notice of withdrawal of instructions from any of his lawyers. And actually, even the accused persons, that is A1 and A2, have equally not informed this court that he withdrew instructions from all the lawyers who are representing him since this matter started. So the assumption is that the instructions are still active. So therefore, when the accused person appears in court unrepresented the way he did last time, it's becoming habitual. And my lord, it is either unexpressed or implied notice to this court that they have waived their right to legal representation of lawyers of their choice. And my lord, this act is frustrating the hearing of this matter, because the principle of fair hearing, all the issue concerning hearing is not only about the accused persons. It is about the accused persons and other parties that are involved, including the public. My Lord, ever since we did our last disclosure, which is I think a month or plus ago, prosecution has been ready to have this matter heard. But we have been arm-twisted, always. And there has been a picture that has been painted to look as if prosecution is the one frustrating the trial or the hearing of this matter. We want to make it categorically clear that we have been ready to have the accused persons tried. Today we have witnesses and we came ready to have the matter heard. My Lord, this in effect constitutes an abuse of the legal process. And my Lord, if the accused persons are abusing the process, this court, my Lord, has tools at its disposal under Section 17 of the Dictator Act to make a finding, my Lord, among others, that the accused persons have waived the right to legal representation of their choice. My Lord, Section 17. My Lord, Section 17(2). With regard to, says, with regard to its own procedures and those of the magistrates' courts, the High Court shall exercise its inherent powers. A. To prevent abuse of process of the court by curtailing delays in trials my Lord, okay, most obliged, my Lord. So, my Lord, I will submit that this court can make a ruling, a finding, based on that provision, that the accused persons have given up. They have waived that right to legal representation of their choice. The assumption, my Lord, here is that under those circumstances, it becomes a voluntary waiver where most obliged, my Lord. And my Lord, court, in doing so, it can direct the matter to proceed for hearing. And in alternative, court can appoint lawyers on state brief to represent the accused person. And my Lord, it is our prayer that court makes a ruling to ensure that we have the matter tried. We are ready. Because if it doesn't, it's going to create anxiety in the mind of our witnesses. And some of them may end up not testifying. My Lord, as the prosecutors or DPP, we are not party to application number 248 of 2026. We are not privy to it, and we are not aware of its contents. And my Lord, we are also equally not aware of the effects of the speech of the President in regard to this matter. My Lord, this court is independent as per the Constitution, and this matter will be tried based
Are you responding
on
to
the
what
facts,
you didn't say?
evidence, and the law.
He's saying
You wasn't allowed to say what
he didn't address that matter.
Most obliged, my Lord. Most obliged, my Lord. Most obliged, my Lord. But he hinted about it, my Lord.
Yeah, but I said it is not here, so you
Most
can't
obliged. My Lord, we so submit.
Yes,
an opportunity to respond in the remainder of what.
yes, very briefly, Mr. Judge. The application it was filed last month. It was raised to the attention of this court on the 30th of June, when we came here to this court. This is also a human rights enforcement application. That we expected would be dealt with as a priority. If it had been dealt with, we would not have been in the dilemma we were on the 3rd. We would have resolved the issue of representation. It was not attended to in the hearing of 30th. It was not attended to in the hearing of the third, in spite of raising it in both appearances. The circumstances that propelled that application were not of our own making. They were the making of the state. Which kidnapped Council Yasenkwago and tortured him. And which arrested and deported Council Martha Kawu. These were the actions of the state. Illegal actions of the state. If they hadn't been there, there would be no application 248. We would have proceeded normally. The details and the evidence in that application can only be dealt with by hearing the application. And if it's baseless, dismissing it. Regarding the lawyers not notifying prosecution, regarding their lack of instructions, that would be a matter for the lawyers to deal with. It cannot be visited on us. But suffice to say that both on the 1st of July and on the 3rd of July, in this open court, we did on the 30th of June, and on the 3rd of July. In this open court, we did put on record the situation of our representation. In their presence.
So, this challenge, how long, according to you, how long can we wait on this legal representation?
If 248 can be had tomorrow and resolved, then the following day we will have a way forward. It hasn't been had since we filed it last month and talked about it in these subsequent appearances. Again, Lord, for emphasis, since it seems Chief State Attorney Bill Momoka didn't get it, the disclosures were made to our lawyers. For us to receive them, we need the facilities through the prisons authorities for the lawyers to now make us access them. So, whereas trial, and indeed they said they had a witness here on the 11th, they had a witness in court. But on the 3rd of July, they themselves read a letter that was now, for the first time, allowing access to facilities, which was written by the prisons authorities on the 29th of June. So we were supposed to hear evidence on the 11th, long before prisons conceded to allow facilities to access the disclosures. By the 2nd of July, when that letter came to our notice, and I'm sure to their notice, the crisis of the lawyers had already emerged. So we have no way of accessing them since July the 2nd, when that letter was written. And until the resolution of the legal representation which they are seeking. Regarding what he describes as abuse of process, then I think there must be completely different understanding of the judicial system, the legal and the judicial system we are following. Mr. Bilivumbuka must be following the indigenous communities judicial system, while we are following the colonial or neo-colonial judicial system, whereas Mr. Museveni said includes judges who are actors with wigs. Yes, Judge, the absence of our lawyers was occasioned by the state itself, not by ourselves. And it is the state that has progressively abused the process. It was the state which took us to defunct military court-martial, military tribunal, which had long been declared unconstitutional. The state, the guarantor of the constitution, nonetheless took us there and charged us in an unconstitutional court, where we spent months. This court ordered for disclosures last year in December to be concluded by January. In a matter where all investigations were complete in May of last year. Yet from December, disclosures were completed in June. Our lawyers begged for sanctions against the state. Every appearance, we wanted the court to sanction the state for not following court orders. Which is the same state saying we are the ones abusing the process. Therefore, constitutional rights must be stripped. So, started being this court to hear our application to resolve the issue of our lawyers. And once resolved, allow us access, allow us time to access disclosures, and also to give us the record of proceedings. And we shall be ready to face their witnesses. As I ask for, say that. Maybe what I forgot, we also talked about other parties which are inconvenienced by delays, saying we are looking at our own situation, not the situation of the other parties. The party, and this is a matter which you also touched on in your ruling on the human rights enforcement application. That those those who apply for human rights enforcement seek to erase the rights of the victims. Our trial is of the nature that, because we are accused of treason, actions against the state. So the aggrieved party is the state. And it is the aggrieved party violating human rights in this case. Coming with gripping hands to seek justice. So I wish to reiterate that our applications cannot be an abuse of a process, cannot injure the other party, because it is the other party that is injuring us. So